That I'll call the case. It's from Geary County, 129-196 in the matter of the marriage of K.L.L. And B.L.B. And who do we have here for the appellant?
Richard Panare
All right.
appears for the appellant.
All right.
And can I refer to my client by name or just by the?
Well, that's up to you.
Okay, I just wanted to make sure there was no prohibition.
No.
Okay.
And who do we have for the appellee?
B.L.B.
Okay. So, Mr. Panare, whenever you are ready, and do you wish to reserve any time for rebuttal?
Yes, Judge, 5 minutes.
That is granted.
Thank you. Your Honor, I'm here today, Your Honors, I'm here today representing Brian Brewer. I believe he's observing on your site,
YouTube?
which I'm pleased that he could do that. He lives in Georgia. Brian was an active duty member of the U.S. Army. His
Well, one of the, let me just, since you mentioned he's still in Georgia.
that, as far as I know,
Is the mother and children still in Hawaii?
as far as I know,
Okay.
I've not had any updates.
All right, go ahead.
A default judgment was taken against Brian. I believe he was living in the home when it took place. He came back. There were orders entered. There was no summer parenting time at all entered in his favor. This case is about an anomaly in the law. We usually cherish the home state rule regarding jurisdiction. And Brian was not favored with the restricted mail notice from his then ex-wife that she was moving to Hawaii. And she did, and that in the record, I've cited the court order complying with the law that she should notify him of her departure if by restricted mail 30 days in advance. She did not do so. He filed a motion in September. She had moved to Hawaii, and because he had no summer parenting time, he asked for 10 weeks because of the move and the distance involved. The lower court judge found that there was no subject matter jurisdiction. Hawaii was not yet the home state of the two children. And it's our assertion that also, if you look in the record, the motion that's cited, there was a motion to modify child support also, and it was intermingled with the motion to modify custody because of the new travel expense that was going to be involved from where my client was living to where she moved to, many, many miles away from Fort Riley. So our assertion is that the parenting home state was
Do you have a question?
Kansas.
I did. I wanted to clarify something because it's my understanding the motion to modify was filed in September of 22, correct?
23, I think. Let me look.
23. Okay. And so at the time the motion to modify was filed,
September 23.
where did the children reside?
Hawaii.
Okay.
They were gone from Kansas. Both parents and the children were gone.
From Kansas.
Yes,
At the time the motion was filed.
that's right. But it was within 6 months and it was still the home state. And the reason there's an anomaly because Hawaii was not yet the home state either until another month after that. So it could have been, but he filed this motion. And I believe the brief of the appellee says that the court lost jurisdiction of the child support. I don't think that's the case. I think there was still child support jurisdiction in Kansas. And
Well, the court resolved the child support part, right?
Yes, it did. And what actually, it's kind of awkward what the judge did. It's not, he did not find that there was jurisdiction for me to seek a modification on behalf of Brian, but he actually, I think, announced some kind of infliction of punishment if she didn't allow visits. And it was kind of an unusual situation, I thought. But anyway.
You said the judge said there was no jurisdiction to decide the parenting issue.
Exactly.
One thing that just struck me as unusual, they didn't get around to filing a journal entry on that until like about a year after the hearing. Was there some sort of reason for that?
I can't recall that, Your Honor. May not have been a really good reason, candidly. I don't recall that, but if that's what you've noticed that, I think that's
Well, I
probably,
presume you did that preparing to appeal.
well, we were
And you
contemplating,
decided to come to this court rather than go out to Hawaii and resolve the matter.
that's true. There was a contemplation of that, but because of the expense of travel there and all, my client decided that we should appeal the judge's ruling. And there were other efforts to resolve the matter, but it's,
I take it there's still unresolved. I'm asking, we're going to decide this case based on the record,
Right.
okay? But these parenting family law cases don't usually get this high because by the time they do, the circumstances have changed all over and it doesn't even matter anymore. I take it there's still parenting issues that need to be resolved.
Your Honor, Mr. Brewer and I have not had contact for me to answer that question frankly, so I don't want to say.
Well, that's what this is all about, right?
I know, but like you said, it's not in the records.
That's what this whole case is about.
Right. It's not become moot as far as I know from Mr. Brewer or from the appellee. So it's still standing. And because the anomaly of there's no,
But there's still a place where jurisdiction is appropriate, even if there isn't a current home state. I mean, the UCCJEA contemplates a situation where neither parent lives in the home state anymore. It's just that
Correct.
subsection B.
it does.
Okay,
But my assertion is because, number one, the lack of notice was one issue. The proper notice, I don't know if you want to call it lack of clean hands or whatever, but that proper notice wasn't given. At the same time, I think the record shows that the appellee in this case was aware that my client had moved because he'd moved to Georgia preceding her move.
But he was also, he became aware that she had moved, correct? I mean, that was the impetus for.
The motion, yes. Yeah, we did become aware of that and he had me file the motion. And yeah, there was no doubt, you pointed out, Judge, that the journal entry was delayed somewhat and there were attempts to resolve the matter. And so there was a definite effort to preserve the status quo rather than appeal right away.
so are you under the impression then that with neither parent living in this state and the children not in this state, that this court can somehow tell the state of Hawaii how much parenting time it should issue to father?
Not telling the state of Hawaii, we're telling the parties. And the point about this is that the state of Hawaii didn't have jurisdiction when he filed the motion. And the anomaly is no state is the home state. So even at that time,
But there is a state with jurisdiction despite there not being a home state.
well, not really. There's not, what other jurisdiction would Hawaii have during the 6 months afterwards, after the move?
Where the children are and where the mother is and where they intend to reside.
I don't think that the code contemplates that Hawaii has jurisdiction the minute the 6 months ends. I don't think the code authorizes that.
It's,
Okay, go ahead.
but it's about the place that has the connections with the family, correct?
Well,
I mean, Kansas no longer has a significant connection.
well, there's no evidence that involved in this question about a motion for change of custody. It's just the fact that she's moved and his time with the kids in the continental United States could not be exercised in the summer or at any other time. So my view of this was that given the anomaly, given that Hawaii was not the home state, that the judge made an error because of the fact that there was no home state at the time and he filed his motion timely for the modification, and it was intertwined with the child support, which the court still had jurisdiction. So we didn't need any factual matters outside the record other than she had moved. He just wanted a modification of his time with the children. He didn't want to change custody or anything. So there was no, when you say there was no connection, there was an existing order that denied him summer parenting time. And that was the whole point. There was no other fact other than he wanted to change and have some summer parenting time. There were other issues directly related to parenting time, but like there's no weekend times anymore that was available. But he wanted to extend and substitute what, for the most part, and have summer parenting time. So it was no other fact other than she was gone that was, so we felt, and I feel that he had a significant connection because he was just trying to get time with the children based on the move, period.
And did that motion to modify also include a motion regarding the notice that was given for the move?
I don't, we made that aware to the court when we were having this argument, but I don't think it was in the motion. Just what
Okay.
was in the motion was the modification of the parenting, of the travel expense as a part of child support too, because of the expense that was greatly increased because of the move. So that's what they were combined together. Thank you.
Thank you.
May it please the court, regarding our arguments here today, I think it's important to know that, yes, we have a default decree of divorce. Dad left the state of Kansas. They're both, mom and dad are soldiers in the United States Army. So dad had a PCS, or a change in duty station, in December of 22, and he moved to Georgia. On April 4th of 2023, mom and the children left. Prior to when mom and the children were still in the state of Kansas, as well as dad in the state of Kansas, dad was asked about his next address. He was asked to provide that to us, and he refused. That is in the record, and our lower court was very aware of the fact that we didn't have an address to provide the notice pursuant to KSA 233222. However, he was notified that she was moving to Hawaii, and he's exercised his parenting time prior to the filing of their motion with the Gary County District Court.
So you're saying there was notice, but it was not provided by registered mail
Yes,
per the statute?
correct.
But
There
there
was no
was
address.
actual notice?
Yeah, there was actual notice, and there was the exercise of parenting time from Hawaii to Georgia. So he knew where she was located. There wasn't any question that the children were in Hawaii after April 4th of 2023. We acknowledge that they did file a motion to modify child support, and then they filed a motion to modify residential or parenting time. And that motion to modify parenting time was filed on September 7th, 2023, after all of the parties had left the state of Kansas. So our objection was based upon KSA 2332 or 37202 A2, which is very clear that once all parties have left the state of Kansas, our court no longer has jurisdiction. We didn't have initial jurisdiction either, so it couldn't come back over to the Kansas. So we are asking.
Even look at that. I don't see where anybody even argued that or looked at it or talked about it, or in district court or on appeal for that matter.
That is, I did not necessarily go that far, Your Honor, but I will say that there was no connection to the state of Kansas any longer. And I do believe that Judge Collett put it in it's in the brief, or in the transcript from that hearing, that after mom moved to Hawaii, there's no longer a significant connection to.
But Hawaii could have had initial jurisdiction, right?
Yes, absolutely. And we've actually asked them several times, why don't you just file this in Hawaii? It would save everybody some time, money, and energy on this, because that's what it contemplates. The statute's very clear. There's no reason to have to go to the comments, but when you go to the comments are also clear that it's the intent of this act that paragraph A2 of the section means that the named persons no longer continue to actually live within the state. Thus, unless a modification proceeding has been commenced when the child, the parents, and all persons acting as parents physically leave the state to live elsewhere, the exclusive continuing jurisdiction ceases. So we believe at that point, Kansas doesn't have the ability to do any orders pertaining to the motion to modify parenting time that's been requested by the respondent in this matter. Unless you have further questions, that's all I have.
Apparently not.
Thank you, judges.
You still have your rebuttal time?
Yes. May it please the court again. The point is that if you interpret the statute as a whole to try to make it make sense, what you're really saying is by the appellee is that from the time they leave, there's no continuing jurisdiction whatsoever in Kansas. Well, there is an attachment involving the child support still. And the only issue involved was the change of this, of a summer visitation. There was no other fact that was of a consequence that needed to be determined, other than the fact that his ability from Georgia to get to Hawaii changed, and it was married up with the child support motion. They weren't separate motions, they were combined.
The summer visitation before.
It was zero.
But before that, though, wasn't even that in Missouri? When the kids had summer visitation with you?
I think yes, I think was at Fort Leonard Wood possibly at the time. I
But we're
forgot
just
that.
looking for ways, why would Kansas have the ability or the connection to be making this call?
Because no other state had the home state jurisdiction.
So I think that while true that no other state had home state jurisdiction, there is a state with better connections than Kansas. The statute doesn't contemplate Kansas is nothing anymore. It contemplates it's not exclusive anymore.
Correct.
And so then you look for the best connections, and
So-
that would be where the children and the mother are and intend to reside.
Well,
Or even maybe Georgia. I mean,
Well, well, the reason, the point is if there were other facts that needed to be developed, you could say Hawaii had a better connection. But the only fact that needed to be developed was that my client would have to go to Hawaii and it would not have any summer parenting time. So the point being is there's no fact in Hawaii that is required to be proven to show, it's the fact that they were there, that we were just trying to modify his time with the kids. And it was married to the child support. So it seemed to me, since there was no home state jurisdiction, they could have filed a motion to say, hey, take this up, and the judges could have conferred. But I would have argued even then, Judge, what fact is it in Hawaii that we need to approve other than the fact that she's there? I mean, and that was so.
Kids go to school there, or at least preschool and other stuff like that.
But we weren't, we weren't disputing anything about school. We're just asking for a summer parenting time.
Okay.
Thank you.
All right, counsel. Well, thank you for your briefs and your arguments. We know this is an important decision, and we know we need to move as quickly as we can on this. So we will get a decision out to you just as soon as we can.